My name is Chu Machinye, and I am your family lawyer. I'm glad to welcome you to Your Family Lawyer, the podcast that brings clarity to family law issues in Nigeria. My name is Chu Machinye, and I am your family lawyer. Before we dive deep into today's episode, let me remind you to hit that subscribe button so you never miss an episode. And if you care about protecting your family's future and avoiding legal pitfalls, you're in the right place. Call us today or send us a message and let's help you take the right legal steps to protect yourself and your family. In today's episode of Your Family Lawyer, we'll unravel the legal maze surrounding letters of administration. You may have heard of it, but today we'll explain to you what they are, who can apply for them, how you can challenge an application for them or challenge an issued one. Why do they matter in inheritance disputes? We'll answer this question and we'll also awaken reality with real stories, real cases, real solutions to the intractable challenges associated with applying for and obtaining letters of administration. First things first, what are these letters of administration? They are legal documents that are issued by a court authorizing one or more persons to administer the estate of a person who has died, and died intestate, that is to say, without making a will. These letters empower the administrator to collect, to manage, and to distribute the deceased assets according to the laws of intestacy in Nigeria that are applicable in various states. And they are primarily governed by the administration of estate laws in the various states, and also the relevant customary or Islamic laws depending on the marital status or religious status of the person who died. Now, who can apply? Who has the right to apply for the issuance of letters of administration? Typically, the spouse of a deceased person can apply, the children of that person can apply, where there are no spouses or children, the parents, and perhaps the siblings may apply, and also maybe any other next of kin, where, like the single gentleman sitting around me here, there are no wives or children, and it just exists somebody who has a relationship. Yes, as any other next of kin perhaps, but just note that the law prioritizes affinity, closeness of relationship with the deceased. The closer you are, the more likely you are to have the right to apply. Now, what is the procedure for applying for letters of administration? The first step is to file a formal application at the probate registry of the High Court where the deceased lived. This application must be supported by documents like death certificate, oath of administration, inventory of the assets, that is to say, a list of what the person owned, perhaps sureties or guarantors who are willing to enter into a bond, depending on the specific applicable laws in the state. And then, of course, mandatorily, the publication of a notice, which is usually between 21 to 28 days. If there is no objection to this application within this period, the letters of administration are granted. In Lagos State, for example, these steps are governed by the High Court Civil Procedure Rules and the practice directions of the probate registry. When you comply with them and nobody is objecting, then letters of administration are issued to enable you to administer the estate of a person who died without making a will. It may also be a case in where the will had been declared invalid or had been revoked by the testator. In some cases, there is partial intestacy, that is where a will does not cover all the assets of a person who made the will, or where the executors, all of them perhaps, are absent or have died or said they won't act as executors. What then are the functions of an administrator when the application is granted? Letters of administration transforms you into a legally recognized fiduciary with control over the deceased estate. While it empowers you to gather and distribute the assets, it also imposes strict legal duties of transparency, and bona fides. You must act in good faith at all times, and you are liable when you fail to do so. And for beneficiaries and third parties, the grant of letters of administration provides clarity as to who to engage with regarding the estate. It offers a clear pathway to resolving issues and finalizing the administration of an estate. An administrator actually plays a great role in managing and distributing the estate of a deceased person who died without making a will. His functions include the following. Number one, he will gather the assets. In other words, take a clear inventory, identify where the properties, monies, shares, and so on are located. This could be in bank accounts, they could be in investment in companies. Then he manages those assets when he's gathered them, to preserve them, to preserve their value, and then to ensure that those who are entitled to it under customary law or under the administration of estate laws get their dues. He makes sure that if the deceased person was owing, such debts are settled, and that if there are taxes that are payable, those taxes are paid as well. When he has paid the taxes and paid off debts, he distributes the remainder of the assets among the beneficiaries, and this must be done according to the statutory law of inheritance or customary laws of inheritance. Then he must keep records of what he has done, accurate records, that is, to ensure that he will be able to give an account of what he has done. In some states, you are required as an administrator to then file returns of what you have done with the deceased estate. The administrator has fiduciary duty to act in the best interest of the estate and its beneficiaries. His actions may be subject to court oversight, and they may need, in some cases, to seek court approval for certain decisions. The administrator is expected to and must act impartially and avoid conflicts of interest, either with himself or the interests of the surviving beneficiaries. He should try to be transparent at all times in dealing with and in providing regular updates to the beneficiaries, because he is accountable for his action and decisions and may be required to provide an account of his administration to the Administrator General. His role is vital and invaluable in the management and the distribution of the estate. So understanding the functions and limits of the powers of an administrator is critical, both for the administrator and for the beneficiaries of the estate, to ensure that you minimize disputes and litigations, which is why we're here today and explaining this to you. You need to understand these things, because if you do, you're not likely to go to court over things that ordinarily, if you understood your right from the beginning, you would have insisted. The guidance of a family lawyer is therefore invaluable in these circumstances. Now, the inheritance under administration of estate laws usually follow this order: the spouse, the children, the parents, and then siblings and extended family. Now, so in administering the estate, you ensure that you follow this sequence, depending on what the law says and depending on what the custom says. When an application is made for the issuance of a letters of administration, it's good to inform you that you can challenge that application. You don't have to wait until it is granted before you can make a challenge against the application to administer the estate of your father or your husband, for instance. And the grounds for doing this in Nigeria include the following. It's important to know that you don't just wake up and apply to go to court and issue a caveat. You go to court and say, oh, this person is not entitled to apply for this application. And you do so based on several legal grounds. It could be a case where there was fraud or misrepresentation, or where you felt you were excluded from being part of that application. I will explain this in small little details, one after the other. First, I'll talk to you about where there is fraudulent misrepresentation. Of course, when there is already fraud, it is usually based on a misrepresentation. So I'm sure you understand what fraudulent misrepresentation means. That is to say, where the applicant deliberately presents false information to the probate registry in order to secure a grant of letters of administration. This could include falsely claiming to be the closest next of kin when he is not, understating the value of the estate, or concealing the existence of other qualified beneficiaries could be some of such misrepresentation. Of course, let's be clear that usually fraud nullifies everything. Anything that is tainted with fraud, if challenged, is usually nullified. And thus, even when an application has been granted, that application is voidable if it is based on misrepresentation. When the family of Okoli and Okoli were involved in this, the Court of Appeal revoked an already granted application, which was issued in favor of the deceased brother, who had falsely claimed that the deceased had no surviving spouse or children, when indeed the man had a wife and had children. Thief. The court emphasized that the duty of candor was sacrosanct in applications for letters of administration. Let me remind you at this point not to forget to click the subscribe button if you're finding this interesting or valuable. Closely related to misrepresentation is suppression of material facts. It's all part of being fraudulent. Suppression of material facts could involve the deliberate omission of key information that would affect the outcome of the application. An example could be where the applicant comes to the court and says the man didn't have a will, when in fact he had a will. That is, the deceased person didn't have a will. It could also be that he says, look, the beneficiaries I have listed here are all the beneficiaries, when in fact there are more known to him. And the courts have consistently held that any material non-disclosure, particularly when done to mislead the probate registrar or take advantage of the beneficiaries, is sufficient ground for revocation. Letters of administration are only granted for intestate estates if a valid will surfaces before the grant of letters of administration. The process will be halted. If it is shown that there's a will, even after the letters of administration have been issued, the court will void that grant of letters of administration. Let me show you what happened in a case where a similar thing happened. An applicant for letters of administration failed to disclose the existence of a surviving widow and her children. He lied that the man wasn't married or didn't have a wife at the time he died. The court, of course, said that was sufficient concealment to revoke the already granted letters of administration. And the court noted that transparency and full disclosure are a prerequisite for such applications. There may be cases where the applicant is not eligible to be issued letters of administration. He may be a person who is disqualified from applying for letters of administration. In Lagos State, for instance, the law outlines the priority list of eligible persons, including surviving spouse, children, parents, and siblings. In other words, only persons entitled under the law, such as the ones I have just mentioned, can apply. A meddlesome interloper, a distant relation who applies for letters of administration, is clearly trying to steal where he didn't sow. That person will be said to lack the requisite local standard or the right to do so. There are other disqualifying conditions, and they include if you have been convicted for fraud or for felony, if you are mentally incapable, adjudged mentally incapable, or you're a minor and you don't have legal representation. Persons who are not related to the deceased can also not apply for letters of administration. In a certain case that was decided in 2001, the court set aside a grant already made to a distant cousin of the deceased who had no superior claim over the surviving spouse and the children. In other words, the man had a wife, had children, he died. His cousin went behind the immediate family and obtained letters of administration. Of course, it was set aside. Let me be clear that usually the basis for grant of letters of administration are like the wife comes up, or a child makes an application. But these claims may be challenged if there is doubt or controversy about the marital status or the biological relationship between the child and the deceased. There could be an imposter wife, a woman who lived with a man but was not married, without legal or customary marriage, or children that are born out of wedlock, who are not acknowledged by the deceased. There could also be even competing claims by multiple wives. Some people marry wives, one is in Gusape, one is in Katankwe, and these cases have happened in our past. For legal consultations or advice, please call us today by dialing the number on your screen. My name is Chuma Chinye, and I am your family lawyer.